Ma'am, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
I understand, yes.
All right.
Welcome back. Today's courtroom session begins with guilty pleas, critical legal decisions, and multiple defendants facing very different futures. Every answer matters because one mistake can change everything inside a courtroom. Stay until the end for every dramatic twist and subscribe for more unforgettable courtroom breakdowns. Like, share. Today.
Yeah.
Yes.
All right. State your name again for the record.
Lamine Kaba.
Okay, you can put your hand down. Sir, it is this court's understanding that you're going to plead guilty to charges of attempted resisting and obstructing a police officer. Those are misdemeanors punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that, sir?
Yes.
All right. You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Garwood. This is going to be 15 to, is that?
Yes, Your Honor, and I also have the MOU for your Honor's signature as well.
All right. Sentenced before Judge Garwood in the 15th District Court. You understand that?
Yes.
All right. Still wish to plead guilty
Yes.
to the charge of attempted resisting and obstructing a police officer as contained in count 4. How do you plead?
Guilty.
To that same charge as contained in count 5. How do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form or had one signed on your behalf?
No.
No.
Could you repeat
Did
that?
somebody go through with you an advice of rights form?
Yes.
All right. And did you give them permission to sign your name to it after they went through it?
Yes.
All right. Do you have any questions regarding those rights?
No.
All right. You understand that you're waiving or giving up all of those rights?
Yes.
All right. Are you on probation?
No.
Are you on parole?
No.
You understand also that you're giving up your right to appeal of right?
Yes.
All right. Has anybody promised you anything other than what's been said here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily and of your own free will?
Yes.
All right. And also because you believe that you are indeed guilty?
Yes.
January 25th, 2025, at the location of 428 Alston Court in Ypsilanti Township, Washtenaw County, state of Michigan. Did you come into contact with 2 sheriff deputies?
Yes.
All right. Man. I think they were. All right. When you came into contact with the sheriff deputies, what happened?
I came into contact with them, and then I tried to go use the bathroom. Well, I acted like I was gonna use the bathroom. Then they try to come in to the bathroom with me to try to do their job, and then I resisted. I got tased, and I mistakenly held the towel rack, and it came out. So it came out the wall, and that's what happened. I got
Okay.
arrested, and
Did
but they,
you?
yeah,
All right. Mr. Cabot, at the time that you were trying to leave, did they told you to stay where you were, and were they trying to arrest you at that point?
no,
No.
no,
Okay, what'd you do that caused them to tase you?
I think I was resisting.
Okay, when you say you were resisting, what were you doing?
I tried to close the door on the police officer's foot because he tried to put his foot in the door. Then I tried to
Okay, so
shut
he
the
tried to
door.
put his, they wanted to talk to you or something along those lines, right? And you put your foot in the door so you couldn't close, so they couldn't close. Well, they put their foot in the door so that you could not close the door, correct?
Right,
Okay. And then you resist, they then tried to arrest you at some point, correct?
right,
And then you did things that resisted that arrest. Is that correct?
yes,
And that led them to have to tase you. Is that right?
yes,
Okay. And there were two officers there at that time?
yes,
All right. Sir, let me just tell you that between the time I accept your plea and the time of sentencing, you commit misconduct as defined under the Michigan court rules. You would not be entitled to withdraw your plea, and any sentence evaluation or recommendation would the court would no longer be bound by. You understand that?
yes.
Counsels, are you aware of any other promises, threats, or other inducements which led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court?
People are satisfied and would like to just make a record that at the original time of contact, the police officers were attempting to contact Mr. Kava because he had left psychiatric emergency services earlier in the day.
Gotcha.
And they were trying to cooperate with a petition to bring him back to services. So he was not going to be subject to arrest necessarily, just to the execution of that petition. I just want the record to be clear about that. So we are satisfied that we comply with the court rule.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea to counts 4 and 5. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered to the extent it is at 15th District Court at Mental Health Court. And you had given us a sentencing day. Sentencing
April 29th at 1:30.
April 29th, 2026, 1:30. That's as to us by the public defender.
That's with Judge Garwood.
And that is with Judge Garwood. Bond will continue.
Your Honor, may I approach for your
Okay.
signature?
Court calls the case People versus Eric Mayfield.
And good afternoon, Your Honor. Assistant Public Defender Alexis Serps with and on behalf of Mr. Mayfield. Mr. Mayfield, can you please state your name for the record?
Eric Mayfield.
All right, what are we doing?
Your Honor, we would just request an adjournment for continued discussions with the people.
Probable cause conference, May 14th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
All right, thank you. Court calls the case People versus DeMarco Henderson.
Good afternoon, Your Honor.
Mr. Henderson, can you state your name, please?
DeMarco Henderson.
The judge accepts the guilty plea, dismisses 3 remaining counts, and orders a pre-sentence investigation before sentencing. That's a significant procedural victory, but sentencing still determines the real consequences. Do you think this plea agreement was fair, or should prosecutors have pursued every original charge instead?
What are we doing?
Setting for a preliminary exam.
Discovery is complete.
To my knowledge.
Pardon?
To my knowledge.
And would people have their witnesses available on the 5th?
Your best, Your Honor.
Preliminary examination in person will be set May 5th,
Your Honor,
2000.
sorry, Your Honor, I'm in a already paid for SCAO conference that day. 2 days, actually. Can I have
Go on a
another,
different day.
please?
Will the 12th work for you or
It will. Thank you.
objection from the people?
Done, Your Honor.
May 12th, 2026, 9 a.m. before Judge Moore. Bond will continue.
Thank you.
Thank you. Court calls the case People versus Koisha Pitts.
Good afternoon, Your Honor.
Good afternoon, Your Honor. Christina Saxon for Ms. Pippins, who's
Am I
approaching.
allowed to leave?
Yes, Mr. Kava, you can leave. Your name?
Koisha Pippins.
All right, what do we,
We're setting for preliminary exam.
discovery is complete?
Yes, it is.
And do people have their witnesses available to 12?
Yes, Your Honor.
Preliminary examination in person, May 12, 2026. 10 a.m. before Judge Washington.
Thank you.
Thank you. Bob. Court calls case People versus Demetrius Caldwell.
And good afternoon, Your Honor. Sydney Rushing, appearing on behalf of Mr. Caldwell. Mr. Caldwell should be on Zoom. And then Mr. Caldwell, if you could state your name for the record.
Demetrius Caldwell.
Thank you. Your Honor, we did receive a report regarding Mr. Caldwell's competency. I did provide a copy to the court. So at this time, I think we're just asking that that be entered and set a review date for approximately 90 days.
No additional evidence from either side.
That's correct. There is no additional evidence from people. We ask the court accept the report from the Center for Forensic Psychiatry. We stipulate to its omission of no additional evidence.
To indicate that this report, it does indicate, and the court has reviewed it, that the defendant at this time is incompetent to stand trial, but likely to obtain confidence. And counsel, I would need an order
Okay,
for the court, please. I will set a review date. Because we can always move it up.
July 23rd.
Set a review date for July 23rd, 2026, 9 a.m.
thank you so much, Your Honor.
You, bond will continue. Court calls case of the People versus Rachel Pichette.
And good afternoon, Your Honor. Sydney Rushing, appearing on behalf of Ms. Pichette. Ms. Pichette, if you could unmute your mic and state your name for the record, please.
Rachel Pichette.
And Ms. Pichette, well, I have before me a plea form. Is that what we're doing?
Yes, Judge, that is what we're doing today.
Form indicates that the defendant will be pleading guilty. Well, it doesn't say.
Yes, pleading guilty, Judge.
Yes.
Pleading guilty to the charge. Use of heroin, the 1-year offense.
That's correct, Judge.
Upon their successful plea to that misdemeanor charge, count 1 would be dismissed. It is also the agreement, the defendant agrees to be placed on probation with drug treatment as a term of that probation and as deemed appropriate by probation or any designee. That's the court's full understanding of the agreement.
That is correct, Your Honor.
And that's correct, Judge. And we've had an opportunity to discuss her trial rights. If you'd like to waive them, accept the offer that the people have tendered.
Chet, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, state your name again for the record.
Rachel Pichette.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of use of heroin. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Do you understand that?
Yes, I do.
All right. In understanding that, you still wish to plead guilty? Well, I
Yes,
do
I
have to
do.
advise you one other thing.
Mhm.
Although I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
I plead guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Correct. Yes.
You signed an advice of rights form, is that correct?
Correct.
Any question regarding any of those rights?
No, not at this time. Thank you.
All right. You signed, actually, I'm going to need her to sign a misdemeanor advice of rights. She signed a felony advice of rights.
Okay, Judge. We'll get that submitted to the court.
You understand that they're contained on the form, but not under paragraph 5. You understand that those rights that are on there, that you're waiving those rights.
Yes, I understand.
All right. Are you on probation or parole?
I am currently on probation in your courtroom with Miss Polara.
Yes. And were you on probation at the time of this offense? I think you
I'm
were.
not sure.
Your Honor, this is from 2022.
It's from 2020.
So
Well,
no, I don't think so.
looks like they changed that to 2020.
Another guilty plea, another reminder that courtroom negotiations often prioritize rehabilitation alongside accountability. Drug treatment becomes part of probation instead of simply imposing punishment. Will this opportunity lead to lasting change? Or will future misconduct erase the benefits of today's carefully negotiated agreement? Watch closely ahead.
All right. Then she still would be on probation to be at this time in either case, quite frankly. All right. You understand that you're giving up your right to appeal of right?
Yes.
You're not on probation, you're not on parole at the time of this offense. Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, I am.
All right. And also because you believe that you're guilty?
Correct.
On, looks like September 22nd, 2020, I think is the complaint has been amended.
Yes, Judge. I apologize.
Did you have heroin in your possession?
Yes, I did.
Had you used it?
Yes.
And did you know what you were using was heroin?
Yes.
All right, ma'am, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
I understand. Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the court rule?
Clerk satisfied.
Satisfied, Judge.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this case will be
May 28th at 10 a.m.
May 28, 2026, 10 a.m. before Judge Washington. Bond will continue.
Thank you so much, Your Honor.
Thank you.
Here. Court calls the case of the people versus Nayeli.
And good afternoon, Your Honor. Sydney Rushing, appearing on behalf of Ms. Lee. I am standing in for her attorney of record, Attorney Costantino. Ms. Lee, can you unmute your mic and state your name for the record, please?
Nayeli.
And Ms. Lee, are you okay with me standing in for Ms. Constantino, giving you the adjourned court date?
Yes.
Your Honor, there is another matter that we are tracking, and there are ongoing negotiations. That other matter has a court date of May 5th, so we are just asking for a date after that date.
May 14, 2026, 9 a.m. Bond continued. All right. Thank you. Thank you, Ms. Lee. Court calls the case people versus David Shukai. People.
And good afternoon, Your Honor. Sydney Rushing on behalf of Mr. Shukai. Mr. Shukai, can you please unmute your mic and state your name for the record, please?
Yes, ma'am.
Can you state your name for the record, please?
David Patrick Shukai.
Thank you. And Mr. Shukai, I am standing in for your attorney of record, Christina Constantino, as she is stuck in another courtroom. Are you okay with that?
Yes, ma'am.
Your Honor, at this time, discovery is complete, and we'd like to ask for a preliminary examination date to be set. Any date works.
People have their witnesses available the 5th. Preliminary examination in person, May 5th, 2026 at
10 a.m.
10 a.m. before Judge Freshour. Bond will continue.
Thank you so much, Your Honor. Great to see you as always.
Yes.
I told you I'd be in person. I came in person. I just want you to know.
Happy. All right, you're okay. You're all set, Mr. Shukai.
Thank you, sir.
Thank you. Court calls case people versus Emmanuel under Ua.
Uruchukwu.
All right, I was close. I think. All right, counsel, state your appearance, please.
Joy Mohammed on behalf of Mr. Uruchukwu. Emmanuel, please state your name for the record.
Emmanuel Uruchukwu.
Thank you.
Your
All
Honor,
right, what are we doing?
I asked for this additional PCC after a couple of weeks ago in order for an opportunity to fully address bond. We had a lot of different issues that we presented at our first PCC. We have a motion that is still outstanding, but my client currently has a GPS tether. We're asking for the court to consider removal of that GPS tether because it doesn't serve the purpose which bond is intended, which is to make sure that the community is safe and make sure that my client comes to court. He has no KPS history. This is a 3-year-old case. And during those 3 years, he had no interactions with the police whatsoever. And so there was an issue last time we discussed as far as what would be the exclusion zone. I don't know if the people have identified that exclusion zone yet. And if they have, I would like for that to be entered into a court order. But like I said, the current tether placement doesn't serve the purpose of what we as a community put people in tether for, and it's causing a financial burden on my client. He is causing attention for him at work, putting his job in jeopardy, which he needs to pay for the tether. So we're asking for it to be removed.
Here comes a pivotal ruling. Despite defense arguments about financial hardship and employment, the judge refuses to remove the GPS tether, emphasizing community safety and the seriousness of the alleged offense. Bond remains, but strict monitoring continues, showing how pretrial conditions can dramatically affect everyday life.
Your Honor, I'll answer that in 2 parts, really. This is a criminal sexual conduct first-degree case involving a minor. The court would be well within its right to deny bond on this case based on that offense alone. I would simply ask the tether remain in place until the date of that motion hearing, so that this court would be fully apprised of what is going on in this matter. I did receive information from my victim's advocate about the exclusion zone the counsel was mentioning just yesterday. And I did talk with court staff about the best way to get that over to you, and I'm going to do that this afternoon. I would ask them to remain in place. 5-6.
I took the home confinement off.
That's correct, Your Honor.
All right. And is there then going to be another motion before me?
There is
It's
an
a
additional
Walker
motion.
motion.
Counsel Miller hearing that is
Right. Okay. All right. Well, other than what I had ordered previously, I don't hear anything that's going to necessarily change my mind. And counsel's right. I could deny bond, which I think would be absolutely inappropriate in the case, at least based upon what I know. But I don't think that the tether is necessarily inappropriate given the circumstances of the case. So I'm going to deny the request for any further change in modification of the tether at this time.
May I ask if the people have the can he clarify as far as what the exclusion zone, what's going on with that?
I have the addresses. I'm going to provide them to staff today.
I'm sorry, I didn't hear you.
He has the addresses. He's going to provide them to staff. Are you talking community corrections staff, or
Yes.
going to provide them to community corrections? And the defendant is notified, but we will not state those addresses in open court.
Thank you. That's fine. That's fine. All right.
Oh.
Thank you, Your Honor.
Thank you. So what I will do then is I will set this probable cause. Your motion is already here. It's set. So I'll keep the probable cause on that same date at May 5th, 2026, 2 p.m.
Okay. All right. Thank
fine.
you. And that will be in person.
That'll be in person.
Thank you.
Thank you.
Is that the 5th or the 7th, Your Honor? 5th is a Tuesday.
It's giving me special date.
Oh, for the motion hearing.
For the motion here.
Thank you.
Correct. Court calls case People versus Jacob Halfacre.
Your Honor, Michael Vincent on behalf of Mr. Halfacre. Put your name on the record.
Jacob Halfacre. Thank you.
Your Honor, I understand that On Monday of this week, the defendant entered a plea in a different case in the 15th District Court. And that part of that plea is dismissal of this matter. So at this time, we would need to dismiss. I'll get you a nollie probably by end of
On both counts.
Well, the whole case
Yes.
should include both counts.
Thank you.
You were trying to trick me, weren't you? Jesus, best.
Thank you.
Thank you.
Well,
Good luck, Mr. Halfaker. Clerk calls the case People versus Josiah Miller.
Question about this for the people.
David I. Goldstein appearing on behalf of the defendant. Mr. Miller, state your name, please.
Josiah Miller.
Thank you. Speaking in adjournment.
Yes, Your Honor, there's some additional discovery that Ms. Feltus and I discussed.
That's correct.
14th work for you?
That's fine for my
I
help.
was looking at the 7th, Your Honor. Is that not possible?
Oh, I can do the 7th.
Yeah, 7th.
That's attorney asking for less time. All right, go. May 7th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continue. Court calls the case People versus Denise South.
Helps for the people.
Good afternoon, Your Honor. Attorney Ryan Reeves here, 73195. On behalf of myself, could you identify yourself for the record?
Denise Self, good afternoon, Honor.
And then, Your Honor. Oops, sorry.
All right. Record should reflect we've had a bench conference in this case. What I will do is I will turn this out at the request of both parties to May 14th, 2026, 9 a.m. Or as your invite indicates, I will also indicate there's a request for travel.
That is correct, Your Honor. My client's niece is graduating from high school in Missouri, which is uncommon, I think, in Missouri. But that being said, she wants to go down there and celebrate these very rare
I like that.
events.
It was something like
It would be like the 8th to the 12th, Your Honor.
No, the 12th to the 18th.
It's the 12th to the 18th?
Yeah.
Oh, see, I screwed up everything because it was
All right.
12th to the 18th.
So let's do this.
Very bad with the
Travel to Missouri. It's including your travel dates, it's the 12th through the 18th.
Correct.
So that's May 12th through May 18th. So give her permission to travel. I will move the probable cause date to the 21st.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
All right. No, sir. Okay.
Thank you. Good to see you again, Your Honor. Thank you.
Seeing you. Court does call the case People versus John Thomas.
Today's docket showcased guilty pleas, scheduling decisions, competency findings, bond rulings, and careful judicial discretion across multiple cases. Every hearing reinforced how procedure shapes justice long before trial or sentencing. Like, comment, share, and subscribe for more shocking courtroom stories and expert legal breakdowns every week.